Welcome to the program. Dwight Professor of Law, Jamal Greene. He is from Columbia University Law School, and his just come out with a new book. It is How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart. Professor, welcome to the program. I'm here with Emma Vigeland.
Hi, good to be here. Thanks for having me.
So you give basically at first you start off with a history of how our, I guess, rights regime in this country developed. Didn't really necessarily come from the Constitution. I mean, let's start there and then go into the Lochner era.
Sure. And the book is really about reconciling the way we think about rights, which tends to be in pretty absolutist terms, with living in a pluralistic society. And a lot of times especially when I make this argument, I see people then invoke the framers and say, rights are absolute and rights are trumps because the framers made it so. And that's really not true. The way we think about rights as being at least presumptively absolute would have been not only foreign to a lot of the ways the members of the founding generation thought about rights, but mortifying to them insofar as we end up delegating to judges the power to decide our rights for us. And the way that the founding generation thought about it, they took rights very seriously, but they thought about rights as something that communities get together to create and to decide on the limits of, right? So when we think about the Bill of Rights, a lot of the Bill of Rights is actually about empowering self-government, it's empowering juries, empowering legislatures, even the militia, which was a form of policing, right? So empowering communities to govern themselves and set the limits of their rights. When we think about the Declaration of Independence, which talks about the unalienable rights to life, liberty, and the pursuit of happiness, they weren't saying, and therefore we got to get judges to come in and say when those rights are activated and when they aren't. The very next sentence of the Declaration is, and that's why governments are instituted among men, is what they say. Because the idea being that you get your rights from community negotiation, community deliberation, and we've lost that, and it's a long story for why we've lost that, but we shouldn't tie that idea to the founding generation.
Right, and so where did I mean, I guess this is a good time to also to expand on when we say rights. I mean, there are different types of rights, right? I mean, both rights, negative and positive rights, or maybe you don't subscribe to perceiving them that way. But when we talk about rights and when you're examining the development of these rights, just explain to us the nature of those rights just generally. Are we talking about individual rights or is that the development that is rather novel?
Well, in a lot of ways, I'm trying to get away from the idea that when we resolve legal disputes, that the way we resolve those disputes is to decide who has a right and who doesn't have a right. That's the kind of polarizing and I think in a lot of ways destructive frame that we tend to use when there are a lot of different philosophical conceptions of what rights are. You can go and take a philosophy course and figure that out, right? But when it comes down to a legal decision maker, whether it's a judge or through the political process, resolving a conflict between people, it's usually not the case that the most constructive way of resolving that conflict is to say one side has a right and the other side doesn't have a right. Usually it's much more kind of brass tacks. What I say in the book is we need to resolve these kinds of conflicts at retail rather than at wholesale, which is to say someone's got a right on one side and someone's got a right on the other side. Someone's passed a law, a public health measure, a public safety law. That's trying to protect rights as much as the person who feels victimized by that law is trying to protect rights, right? So rights are in both sides of lots of disputes that we have. And it's very easy, I'm a law professor, it's very easy for me to construct an argument for why the Constitution protects the rights on both sides of just about every conflict we have. And so saying who has a right or who doesn't get us very far. And what we need to do much more of is thinking about, well, why did the government pass this law? What alternatives might there have been? Who's burdened, who isn't burdened? How far, you've got to make a judgment call about a lot of these things. And we've gotten away from that. And we feel as though we've got to sort of assign a constitutional right to one side or the other. These are retail political conflicts that we have about our rights. They're not metaphysical existential crises.
Well, I mean, that undercuts, I feel like, so much of how judges view themselves, right? I mean, there's so much judicial activism that takes place. I know you write about some of that. Can you talk about how this perception of rights, I guess, makes conflicts or disputes susceptible to kind of judges looking at things through their specific lens and tailoring them in a bit of an activist way?
Well, I hesitate to use the word activist because it's so politically charged,
Sure.
and one person's activist is another person's, constitutionalist or something. But I do think, to the extent that what that gets at is a kind of self-aggrandizement by judges, right? Judges feel like they are the ones who decide our rights for us. I do think that the tendency that I'm trying to criticize in the book does lead to that, right? So let's say there's a dispute about the First Amendment or about a political ad, right, or a political. So Citizens United, which we all remember that at least the name of that case, which is about an ideological corporation that wants to run an anti-Hillary Clinton movie right before the 2008 election. We frame that, lawyers frame that, the public frames that as a First Amendment case. It's a free speech case. Do corporations have free speech rights becomes the question. Judges understand themselves within our system as the ones who answer that question, and they answer it by looking at precedent, looking at the text of the Constitution, looking at maybe thinking about what the framers thought. These are kind of legalistic ways of answering those kinds of questions. Judges are essentially justifying their own authority by saying the way we resolve a dispute about a Hillary Clinton movie is by referring to text, history, precedent, lawyerly things, because why else would judges be the ones resolving these conflicts? There's no reason why that has to happen unless you commit yourself to an overly legalistic culture. So what's the other way of thinking about a conflict like Citizens United? Is to say, well, yes, there's a speech right at issue here. There's a corporation an ideological corporation wants to engage in speech. There's also a political equality issue here because the government's passed a campaign finance law that's trying to equalize citizen access to the political process. So you've got constitutionally important rights on both sides of that dispute. Instead of thinking of it as just do corporations have free speech rights? Let's think of, well, are ideological corporations different from General Motors or someone who makes widgets? What is the precise burden on a company, on Citizens United, where in the case itself, it was actually about whether they had to set up a separate political action committee versus using their general treasury funds to spend money on this ad. How burdensome is that? Right? Those kinds of questions are not the kinds of questions the court answered. And in some ways, I think that's linked to the self-conception of judges as trying to decide our rights for us. And that's, I think, terribly destructive.
How would, and I want to get back to that sort of the Lochner case where this sort of I think you peg this as sort of developing, but how would how would, though, just to use your example, how would lower courts be able to address these issues? I mean, I am of the mind that the judges are doing exactly what you're saying. It's just that they, in certain instances, they don't necessarily decide in the way I want to, and they're dressing it up in some type of framework so that these future questions can be answered. But I mean, is it possible to have looked at every single case in its specifics, or don't you need some type of principle, legal principle, to maintain the architecture of the legal system? I mean, I got to say, I'm skeptical as to the sincerity of that architecture, but that is like the pretense, isn't it?
So it's a fair question, and there's a couple of questions embedded in there. So one is about precedent, and how do you sort of maintain precedent in the, we think that judges have to figure out what the rules are, right? And those rules are going to be overbroad and generalizable, and that gives advice to the lower courts. And then there's a separate question here about sincerity and about, is this all just kind of a game? And if you're just kind of, shifting the deck chairs around, does that really change anything? As to the first, I think it's really a matter of what kinds of questions does a court ask when they receive a case. So precedent can mean, when I see a case like Citizens United, I've got to figure out, what does the First Amendment mean? And that's an interpretive question. So you might look at the text, you might look at particular precedents around what is the scope of your free speech right. The other way of looking at this is to say, to ask a different set of questions. So what kind of law is this? What was the evidence on which this law was based? What are the purposes behind this law? What are the alternatives available? Those kinds of questions can also generate a set of precedents around the facts of the dispute. So it's different ways about thinking about facts. Well, what are the relevant pieces of information that I need to solve this kind of case? And I'm trying to urge that information to be based on facts in the real world, as opposed to being based on legal abstractions. So on the second point, does this really affect, I'll just crudely characterize your question as, is this going to change anything? Does this affect any outcomes? If it's just a matter of, judges are just going to reach out, they're going to reach the same result anyway. And, you're just urging them to dress it up differently. And that's a fair criticism. And I'm not suggesting necessarily that in all of the hot button disputes that we have, that outcomes will come out differently. I do think that what I'm trying to urge is the conversation that cases generate to focus on a different set of questions. So just to go back to that Citizens United example, if I'm left of center, right? If you ask me, do you believe in corporate speech rights or do you believe in political equality? Right? I'm going to say I believe in political equality. You ask someone right of center that question, they might very well answer it differently. And so that in that way, that the case just recreates the same kind of ideological disputes that we have. But if you ask me, should an ideological corporation be able to use its general treasury funds to fund a movie that a video on demand movie, so people only get it if they ask for it, in the weeks leading up to an election where they're criticizing one of the candidates, I might be able to go for that. And so might my right of center friend, right? So there are ways in which we can dial down, depending on the kinds of questions we ask, dial down some of the conflict that we have around. We can talk about consent where we have consensus and where we don't. We might still reach different judgments in cases. Of course, we're all different people, right? But there are ways in which judges and other legal decision makers can help with dialing down the temperature of political conflict, and there are ways they can hurt. And I think right now they're hurting.
I want to circle back to that premise, which is the central premise of the book. But let's go to the Lochner case, where you cite that case as being sort of, I guess, the beginning of the development of this notion of or I don't know if it's the beginning of the development, but it's really when it starts to sort of come to the fore in terms of the development of rights on some level.
So sure, yeah. So the Lochner case, and I don't know how familiar your audience will be with this case. It's one of these things that all lawyers know, but most non-lawyers don't know.
Well, they should be, but we'll see.
But it's a very important case where New York passes a law that says that you can't work more than 10 hours a day or 60 hours a week in a bake shop, and passes unanimously in the New York legislature. It's a health and safety measure and a labor law, and the Supreme Court strikes it down. And this case is understood as sort of standing in for an era of, I'll go back to Emma's word, judicial activism, where judges are reaching out to apply their ideological lens to the sort of laissez-faire economics ideological lens to lawmaking, And within the legal culture of the United States in the middle of the 20th century and beyond, we think of that case as being just egregiously wrongly decided. Every member of the Supreme Court today will say that the Lochner decision is wrongly decided. And
Is that right?
that's right. Yeah.
I worry. I mean, there's some, right? I mean, don't we have to like, let's put it this way, not as vociferously as maybe the Supreme Court 10, 15, 20, 25, 30, 35 years ago.
I think that's fair. And there are certainly elements of the conservative legal movement that would not say that Lochner is wrongly decided. I think that they haven't made it to that group hasn't quite made it to the Supreme Court, and so it's still a mainstream position. I'll say that Lochner is the worst of the worst, and conservatives and liberals tend to pick at different parts of it. But what it does in our history is it sets out one strand of thinking about rights, and opposition to Lochner ends up taking the form of when the government is engaged in certain kinds of social and economic legislation, you just let them do it. Because if you don't let them do it, you're going to be making lots of judgment calls in the way that the Lochner court did. And the Lochner court is wrong, and so we should give deference to the government. But there's, of course, another strand that says when rights are at stake, of course you don't give deference to the government, and that strand is the Jim Crow strand, right? So middle of the 20th century, Brown versus Board of Education, you don't trust the government at all, right? So we have these two competing notions of rights in our head that results from just the baggage of American history, one of which says you defer entirely to legislatures, and the other of which says you defer not at all to legislatures. And what ends up happening in the 1960s and 1970s is you get a lot more rights cases that don't fit comfortably in either of those categories, right? So you get a birth control law or a law where someone's challenging the government taking away their welfare, or someone's trying to burn a draft card in protest of the Vietnam War, and that's being criminalized. So do you defer entirely to the government because the government should always be able to, penalize, to decide on people's welfare rights however they want, or do you defer not at all to the government because important rights are at stake? Well, it's going to be somewhere in the middle. And we never really constructed a language for dealing with the mine run of rights cases, which are between the extremes of no deference to the government at all and complete deference to the government.
So I'm just trying to understand that. Like in the Lochner case, the idea was that the Supreme Court was saying that the right to enter into a contract needs to be is sacrosanct and can't be impeded by government. And then in Jim Crow, you have people saying that is it really just a question of like whether or not you defer to the government, or is it that, well, the basis in which in Jim Crow, for instance, we have a whole series of amendments that came out through Reconstruction to the Constitution that the Constitution trumps. It seems to me far more explicit in terms of rolling back Jim Crow laws than it would in protecting the sacrosanctness of contract. I mean, isn't that what that comes down to? I mean, aren't you flattening these a little bit as just a response to I should or should not defer to the government, or is your argument that that's what happened, that it was flattened?
So my argument is that that's what happened, is that it ended up being flattened in that way, even though rights are much more contextual than that. So a couple of things on what you said. So one is the way to think about Jim Crow versus Lochner just a matter of what's explicit? I think not. I think both of those are 14th Amendment cases, and the 14th Amendment doesn't, at least Section 1 of the 14th Amendment doesn't mention race at all. And the people who wrote the Lochner case thought they were interpreting that same amendment in that same section as the people who, as the Brown court. Now, I of course think Brown is rightly decided, and I think Lochner is wrongly decided. But I don't think that the reason why one is rightly decided and one is wrongly decided is one involved rights and the other one didn't. I think they both involve rights. I think the right to contract is a right that people have and should have, and it's very easy to specify it constitutionally. but it just doesn't go nearly as far as the Lochner court thought it went. And that's in fact what the Lochner court said. It didn't quite say that the right was sacrosanct. It said it depends on whether the government has good reasons or not. And there were two dissenting opinions, and one of them said, well, yeah, that's right. There is a right to contract, and it just depends on whether the government has good reasons or not. But I think the government did have good reasons. That's Justice Harlan's dissent in Lochner. The much more famous dissent is Justice Holmes's dissent, where he basically says, no, there is no right to contract. This is a silly case. And that dissent ends up being the one that kind of defines that strand of rights thinking in the United States. For lots of, again, historically contingent reasons having to do with Felix Frankfurter being a Holmes acolyte and kind of distributing pro-Holmes views to all of his disciples. But that's the way legal education ends up working. And when we get to the 1960s, everyone's running away from the idea that you can have kind of rights that aren't complete, right? The right to contract, which Justice Harlan would have said, yeah, this is a right, but it's limited. That language of this is a right, but it's limited, ends up sort of not having any traction in US constitutional law. It does have lots of traction elsewhere in the world. And I think, and there are a number of comparative examples in the book, I think quite productively has a lot of traction elsewhere in the world. And what it comes down to is, look, when you live in a complex pluralistic society, everyone can't have absolute rights, right? So because they're going to conflict all the time. And so you have to decide, either everyone kind of has partial rights that are kind of resolved, mediated is the word I use in the book, or you have to decide who has rights and who doesn't. And we've ended up picking the latter, and that's really polarizing. And I think it's not something that judges, going back to Emma's question, it ends up giving judges an awful lot of power over who ends up being a rights holder. It's one thing to have power over who wins this case, but power over who gets to be a rights holder is power that judges should not have.
And so let's talk about that proportionality analysis and this idea of reconciling rights and how it plays out in other countries. You write about Germany, particularly in the context of abortion rights. Walk us through that. And also, I'm curious as to whether it's because they have a fundamentally different legal system in the way that just even like plaintiffs come to the court or defendants, and the way that the judges perceive, they don't have necessarily the same sort of adversarial qualities necessarily that we do. Will you explain, walk us through that? Sure.
And there are a number of different comparative examples. And Germany, as you mentioned, there's a whole chapter on German abortion jurisprudence, which I can say something about. But Canada is also an example that I refer to a number of times. And the Canadian legal system is pretty similar to the US legal system in terms of how cases are brought, the structure of the Supreme Court, the structure of lower courts. And sometimes when I make this argument, people worry about chaos, right? And Canada is not a chaotic legal system. I mean, they work it out. So anytime, if part of the concern is, the German system is too far from ours, well, there's also Canada. So the Germany case, so I talk a bit about abortion rights, and I'm always try to be cautious when I talk about this issue, and particularly whether we can make progress on this issue. I don't know if we can. All right, so the chapter means to say, look, there was a moment in the 1970s when there were some choices that courts could make about how to structure abortion rights jurisprudence. And German courts, and courts in a number of other places as well, but German courts in particular, made a choice to say, we're gonna think about rights being on both sides of this dispute, right? So the Constitution protects the value of fetal life, and that's a very important, I'll call it a right, they wouldn't use quite that word, but protects the value of fetal life, and it also protects the autonomy of women. And so the way this dispute has to be resolved is in a way that respects both of those. The government has to respect both of those. And what ends up happening is that the political conversation in the German context responds to that by arriving at a consensus topic of conversation that responds to both of those things, which is how do you give women more genuine choices, right? So if you are from the anti-abortion rights side, and someone says you've got to respect women's autonomy, they say, well, how about we respect women's autonomy by making sure that abortion restrictions don't arrive till the second trimester, for example. And so you've got basically liberalized abortion access in the first trimester, but the second trimester you need to have a particular reason. And from the other side, the pro-abortion rights side, well, we think that the way that if you're going to restrict abortion rights, you've got to make sure that women are actually given genuine choice, right? So do they have prenatal care, right? Do they have postnatal care? Do they have child care? Do they have employment guarantees? If you want to save the life of a fetus, right, the way to save the life of a fetus is not to restrict abortion. That's going to lead the practice underground, right? The way to save the life of a fetus is to make a woman make a different choice, or to incentivize her to make a different choice, to make her life easier as a parent. And so there's a grand compromise, political compromise, spurred on by court decisions around, and people with very different views about abortion rights, construct a regime. And the regime is, pretty liberal access in the first trimester, funding for people who have trouble paying for abortion access, which isn't a thing at all in the U.S. In the second trimester, it's an indications model, right? So, if there's a medical reason or a health reason, or then you can get a so-called indicated abortion. Look, lots of people are not going to like that regime, right? Lots of people are going to think it should be more liberalized. Lots of people are going to think it should be less liberalized. But the point of the chapter is to say that the court decisions spurred a political solution, so that and vastly lowered the temperature of the issue, so that in the 1970s, abortion was a more controversial topic in Germany than it was in the United States in the early 1970s. And today it's not even, it's just not, they're two different universes. And you can trace ways in which court decisions contributed to that. Roe versus Wade happens the same time as that German case that I referred to, more or less the same time. But there the court insists that we can't think of fetal life as having any constitutional value. Because if we did, and since we think of rights in this sort of almost absolute sort of way, then that would mean that the women can't possibly have their own abortion rights. The court doesn't have the imagination to think of those things as coexisting. And that actually ends up fairly directly dividing the anti-abortion movement between people who were much more moderate forces within that movement in the early 1970s, and they get kind of kicked out of the movement by much more extreme activists who call for constitutional amendments and changing the court and all sorts of things. So it's not to say that this is such a polarizing issue today, right, that it's hard to know exactly what to do with it. But it's to say there were other options, and there's some evidence that those options led to a much more productive way of thinking about this issue.
Does this conception of rights, I guess, I mean, it I think allows for judicial power to be more ubiquitous, as you're getting at, and that then it necessarily needs to be in the United States. And it's almost like we're, with this new conception of rights that you're laying out, it's kind of asking judges to relinquish some sort of discretion and power that they seem to wield, I think, with more enthusiasm than perhaps you'd like. I'm just trying to see how they could adjust their perspective, because them, behaving in this way, it kind of suits their power interests, does it not? This conception.
Well, in a sense, I mean, I think how the power plays out. One of the lines in the book is, judges should recognize more rights, but they should be less strong, right? So they should be more willing to say there are rights at stake here, but less willing to say that means that resolves the case, because the case will get resolved in other ways. there are ways of characterizing that as judges grabbing more power, right? And I think sometimes it's characterized, the argument is characterized that way. Sam mentioned positive rights earlier in the conversation. This way of thinking is much more open to the possibility of positive rights, or right to health or right to education. Right? There might be circumstances under which it makes sense for courts to step in and say, the state doesn't have a good enough reason for not providing this vital resource to people. I talk about from the 1970s, a well-known case out of San Antonio involving the use of local property taxes to fund local schools, where there's an equal protection, an equality challenge, and a right to education challenge brought against that. And it loses. And part of the reason it loses is the judges say, it's 5-4 case. Lewis Powell, who writes the majority opinion, just says, look, we can't, he's a big anti-communist, right? He says, look, this would be communism. Like, we can't have equality of all the positive resources that are provided by the government. And so therefore that must not be a right, right? And what I want to say is that kind of reasoning, you can say that something's a right, but also say that doesn't mean that courts are going to order the government to provide it absolutely and to everyone. These schools were, sort of manifestly unequal, and there are ways of making them more equal. And, judges have to do what they can within their resources to help that. So in that sense, whether they're getting more power or not sort of depends on the case and depends on how we're thinking about their power. I want their power to be continuous with political power, which is to say, the kinds of things that judges are talking about should be the same kinds of things that politicians are talking about when they talk about the resources available to particular schools in a case like the San Antonio case. What I worry about is judges converting what is actually a political dispute on which they have a role to play, right? They can set the bounds of that politics, but converting that political dispute into a question of like, where are the commas in the Constitution, which is not what the dispute is about. That's an abstraction.
Is there a chicken and egg? I'm curious as to whether we find ourselves in this dynamic, and I certainly, the idea that these political fights are being turned into sort of more, into argument about rights, resonates with me. But is this not by design? I mean, the idea that, I don't think it's, and I understand, abortion is sort of almost a unique issue, but in some ways it's unique because it was meant to be unique. That the reason why it was more contentious in Germany in the 1970s is because there was yet to be, a movement that chose abortion as the sort of vanguard of that movement, when it was really ultimately about taxation and being able to segregate your colleges and still get a tax, a freedom, you didn't have to pay, a tax as an educational institution. Like, aren't we looking at the product of a political machination rather than a native impulse within judges, but rather the assertion of politics onto our judiciary?
So yes, I mean, it's an astute point, and I think it's right to a degree. But what I'd say is there politicians are going to politic, right? They're going to be opportunistic. And the abortion story is certainly an example of that. But from my perspective, as a lawyer, as a law professor, as someone who can try to make an intervention from my corner of the world, there are ways of making that opportunism easier and more efficient, and there are ways of making it less efficient. And there's only so much courts can do. I'm not a utopian about courts or someone who thinks that they can solve all our problems, but they can make them worse. And I try to track a lot of ways in which that's happened, both in the 1970s and today, within the book. And And so, you know, there are lots of problems with our politics, and there are lots and by the way, I'll say opportunism is inherent in politics, right? It's not something that's always a problem, right? But I'm trying to say, what can the legal system do? How can it make things better rather than making things worse? It's not going to solve our problems. How can they shape conversations? Are they leaving money on the table? And I think there are a lot of ways in which they are.
Jamal Greene, the author of How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart. We'll put a link to your book at majority.fm. Thank you so much for your time today. Really appreciate it.
Thank you. I appreciate it as well.